Good morning and welcome to another episode of Law and Order, the program where we discuss about legal matters. On today's episode, we are going to discuss about the process and what happens and the issues related to winding up of a company. And we have with us today Nishant Sydney Premathirathna, attorney at law, who was previously here to discuss intellectual property. So make sure you watch that episode as well. So good morning and welcome on the program, sir.
Good morning, Prashant. Great to be back. Thank you.
Okay, now to start off, I'd like to ask you to give us an introduction about the process of winding up a company.
Yes. Now, Prashant, as a natural person, even a legal entity like a company has certain duties and obligations, and it also deals with the world at large. Now, when you deal with the world at large in respect of business activity, you will there might be certain loans you take, you might borrow, you might get goods on credit, you might also have invested in certain other projects, you will also have people like shareholders who are the actual direct owners of the company. Then you have the directors who actually monitor the affairs of the company. So the directors only decide on whether the company can actually pay its debts when it comes due and continue as a going concern. Okay. So a company has to be able to decide at any given time that it can keep doing business and at any given time settle its dues and do a self-assessment and continue engaging in business activity. Now, when it comes down to situations like possibly the economic crisis, it would have hit most businesses, and we will probably feel this in a bigger magnitude next year, where most businesses will want to close shop. They'll want to shut down. So when they want to shut down, they have to be able to do it. They can't just do it. They follow the procedures in terms of the law. So the law governing a winding up process is set out in the Companies Act, and also the winding up rules of companies, which is a very old piece of legislature, that is of 1939. So you have to go down that road to close shop. You can't today, so hypothetically, if you're the biggest company in Sri Lanka, you can't decide today morning, from tomorrow onwards, we are going to terminate all dealings with the world. You can't do that. You have to go down a procedure. So either the directors can get together and pass a resolution and go down this thing called a voluntary winding up. You go down voluntary winding up, where you decide that you can't keep continuing doing this business and you want to close shop. But for that, there is an underlying requirement that you have to be able to satisfy the solvency requirement, that you are still in a good financial standing. You are not in a bad wicket. You can't go into voluntary winding up if you are at that instance unable to pay your debtors. So, pay your creditors. Okay. So in voluntary winding up is a seemingly limited situation. But the other two options are where you want to go to court and get the court to monitor this winding up process. So the company can on its own go to court, or it can be where any creditor, so say hypothetically a company has supplied goods worth 30 to 40 million. Say this company is in the construction industry and it has supplied goods, the creditor has supplied 30 million of goods to the company. And then the company has delayed in paying and has now defaulted. So then a statutory demand can be placed on the company. And if the company does not comply with that demand within a certain period of time, in terms of our law, it's 3 weeks. If the demand is over 50,000 rupees, you can take that document to court, to the Commercial High Court, and get the court to order the company to be wound up. Right. So these, in a nutshell, this is the process. These are the instances on how you can commence a proceeding to wind up a company.
Okay. And what are the advantages for a creditor to seek winding up?
Well, personally, I do not believe that the creditor gets any advantage, because what happens is, if a court of law decides to wind up a company, then thereafter the next step is to appoint a liquidator. A liquidator is a court appointed officer. the liquidator is thereafter required to continuously report to court.
Right.
So once the liquidator is appointed, the directors who were running the company, they are defunct or they are functus. They lose their power to manage the company, and the liquidator is the guardian of the company. So the liquidator then goes through the company's assets and its liabilities and decides how best it can go about settling all of this. So generally, if a company has come to this stage of being wound up, its finances are not sufficient to meet the dues. So there might be a serious discrepancy between the two figures.
Okay.
So in such a situation, if a creditor takes the route to wind up a company, it might actually not get the due amount pursuant to the winding up procedure concluding, because you have a lot of people in the food chain. So you have secured creditors, you have unsecured creditors, you have the employees who will also be required to be paid their EPF, ETF. Then also ultimately the shareholders are also there in that. So they get paid last. So if there's nothing remaining, the owners of the company don't get anything. But my personal opinion, though creditors take it upon themselves to take a company into winding up, the ultimate benefit is not, it is minimal unless your amount is not very significant. But if you are a bank, you have lent 8 to 10 billion. Now there are ongoing cases in court where financial institutes have lent serious amounts of money to certain companies who have gone bust. So now they're winding up processes. Financial institutes do not come and support the winding up. They actually object, because they know if you kill the company's balance sheet does not show these amounts of figures to be paid. They do not have the capacity to make payment. So it's better to keep the company going and ensure that little by little, even through the company's earnings, you can get a recovery.
Okay.
So whether there is a distinct advantage, possibly for a creditor, it's to put pressure. You get the directors of the company, when you lodge the winding up notice, they might come and give you some, identify you and immediately settle you, because they run the risk of being killed or being wound up.
Okay. Now, what are some of the defenses or remedies companies can use against winding up?
Well, now presently, the most, not merely companies but even individuals, they might have difficulties with already obtained loans, and borrowings might also be much harder to fulfill, because interest rates have also gone up, and overall businesses have come down during this economic crisis. So the central bank has also issued a circular in July, which has mandated the banks and the financial institutes to have discussions and negotiations with all borrowers and ensure that some form of restructuring is given, some grace period is given, and as per the circular, any recovery actions against any party, may it be companies or individuals, are supposed to be halted till the end of this year, 31st of December. So you might be able to use that circular as a defense, or it can be where the company can take up the position in the court proceeding that this debt is not an identified debt, it's not a certain debt, and they have a certain defense. So this is uncertain, the amount cannot be quantified. So that sort of a defense can be taken, and sometimes courts might dismiss the application to wind up a company.
Liquidator is considered as a guardian. Let's talk a bit in depth about the liquidator's role.
Yes, so now, as I mentioned, once a court makes that order to wind up, that is called the winding up order, the liquidator is then required to be appointed. And then once the liquidator is appointed, the liquidator takes control of the company's affairs. He obviously gets a fee, he gets a significant portion of the company's, not a significant portion, but a percentage of the company's as his wage. So he takes control of the books, and he can go and inspect the company's properties, inspect all the books. He can ask for all other records maintained by third parties in respect to the company. He can go into cases where the company is a party and take steps to defend the company, or he can file action for and behalf of the company also. So the liquidator has a lot of power. Liquidator but is continuously monitored by the court which appointed the liquidator. So he can't go on his own will and frenzy to do certain things. He has a scope, when the scope is that is monitored by the Commercial High Court itself. So the liquidator generally continuously files reports. So these in a winding up matter in a court, there are so many parties who will come and get involved. The creditors will come, so they will all want to be a part of this winding up inquiry and have a lot to say. So the liquidator will get a lawyer to appear for him and make representations. But now most liquidators are quite competent on their own. They make submissions to court even without because it's more of a fact submission. They submit the actual status of the company.
Okay.
So at the ultimate end, the liquidator will submit this thing called the final report, and he will say that now I have done this, I paid X, Y, and Z, and everything is now done and dusted. This company has settled all its dues with the money, not all its dues, but settled whatever dues possible from the remaining monies it has, and now there's nothing more to do. And that will be the final liquidator's report, and thereafter the company's name is struck off from the Registrar of Companies registry once that final report is submitted.
Okay. Now, what are some of the dangers of directors of companies taking deposits of public money and mismanaging them and then seeking to wind up?
Yes, so now this is a serious concern. Now, because directors, they control the shots. When you're a director, you have director's duties, you have obligations, you are continuously under scrutiny. And in terms of a Companies Act, if you have done certain wrongdoings, you can be imprisoned as a director. So as directors, you have to always ensure that there is proper financial management of the company's proceeds. Now, there have been in the past certain matters which are ongoing where directors have mismanaged companies which have possibly been empowered by certain laws to take deposits from third parties and with assurances and securities, but because of their mismanagement and siphoning out of funds or allegations of that, they have lost the ability to repay these depositors. Now, certain people, certain public members of the public might have infused all of their life's earnings into this, probably in the anticipation of getting high interest. So now when it comes to a proceeding of winding up, and if you go into a winding up situation and the winding up commences, then ultimately the liabilities of a company are limited to the corporate's assets. You cannot go behind. Now, if hypothetically I am a director of a company and the company cannot pay its dues, I can't be required to pay out of my pocket to settle the creditors. That is the standard law. But unless and otherwise, you can allege in terms of our law, in terms of our Companies Act, that there was fraudulent trading by the directors. The directors have identified certain creditors and given preferential treatment to them. So now hypothetically, Prashant, I run my company. Now I know me and my friend are both directors of this company, and we know the times are hard, and we don't have the capacity to maintain it as a going concern. But then what do? We try to settle one or two of our friends who have lent money to this company. We, without no reason whatsoever, we make payments to them. So that is not permitted in terms of the law. That can be construed as a fraudulent trading element.
Okay.
So in a winding up proceeding, if you can unearth this sort of information, you might be able to make an application to that court itself to name these directors as suspects and seek for the commercial court to seek the advice of the Attorney General to indict them or to file criminal proceedings against them in order to possibly recover monies due from them to the company because of their illegal acts and their preferential payments being made.
Now, let's speak a bit about relief to borrowers when financial institutions such as banks seek to recover their proceedings.
Yes, so that I think, Prashant, I mentioned, so that is this circular which is there. So you can rely on that. Presently that's in force, and you can seek for a grace period of 6 months until the 31st of December, and even after 31st of December possibly it might be extended also. So there is a cap on interest rates also. So banks are not, or in terms of the circular by the central bank, they cannot claim more than a certain stipulated interest during this period. So if the banks want to claim about 22, 23, 24% on your on the borrowing, saying that you were given a floating rate, this circular might come in the way and block that, because my memory serves me correct, the upper limb is about 15%. So the central bank has said don't go and claim more than 15% for as interest during this period, because we all know the interest rate suddenly shot up, and now the times those borrowings were effected, possibly the rates were single digits, and now we are possibly looking at 25 to 28%. So the circular can help you, and also if worst case you can go to a court of law and seek to establish certain defences in respect of the procedures effected for parate execution, which is a quasi-judicial sort of arrangement which the bank is empowered to execute the sale of a property, but the law says that those are very strict and the bank cannot deviate from the set out procedures, and any slip in that procedure can be held against the bank to stop such execution. So those are remedies available to any aggrieved party to go to a court of law if the financial institute is not listening to you, not taking seriousness of this circular. You might be able to agitate that in a court of law in precluding any form of recovery against your assets.
Right. Now let's talk a little in depth about those remedies that you mentioned if parate actions are instituted against a business.
Yes. So as I mentioned, the banks have a very strong power in terms of those laws.
Yeah.
So it's a very it's given a lot of ability to the bank to decide ex parte without even too much consideration. They can decide to execute or recover on the security which you have pledged on the bank. So but when the bank embarks on that procedure, you are left with the ability to challenge the procedure they have taken. So the publications of the notices of parate, the quantum which they are claiming, whether they have claimed penal interest, whether that interest was agreed to be claimed from you. So all those are elements which you can agitate as indifferences and irregularities which have taken a place against you. So you are, most instances when a parate execution is to happen, litigants try to go to a court and look at these irregularities or bring them to the attention of court, try to stop the auction, because it might be your house, it might be your building, and you have pledged it to the bank, and now they are trying to auction it, and they can auction it at any price. That might seriously be detrimental to you in several years to come. So you might only want to go through this economic crisis right now in order to meet these requirements of repayment at a later date. So you just need that little bit of breathing space. As a borrower, you only need the small window to be able to get the ability to repay. So circular is there, that is a very strong tool, but in addition these general deficiencies which can be highlighted are also the remedy available when you go to a court of law.
Right. And finally, let's speak about companies really restructuring its due in terms of the Companies Act.
Yes. So now winding up is not the only solution. You are not trying to, as a company, The idea behind becoming a company is to be a going concern. You want to be able to continue to do business. Going down the road of liquidation and winding up means that you are going to your death, which is not generally what businesses want to be doing. So they can go down the process of having meetings with creditors. They can have a creditor arrangement. That creditor arrangement can be agreed and thereafter used even to delay certain recovery proceedings against the company, and then or you can appoint people in the capacity of receivers, managers. Those are also abilities and provisions available in the Companies Act to not go down the road of liquidation but look at restructuring. So creditor arrangements are something which is now commonly seen, where you get all the creditors to a meeting, you agree with them, or you give notice of a creditor meeting, and with that notice you are able to get a grace period of about 2 to 3 months in terms of our law. And during that period you can negotiate and agree, like the whole country is doing that now. The Sri Lanka is doing that with its international and local creditors. They're trying to restructure the foreign debt and also possibly the local debt at a later date. So all the creditors have to agree together that we don't want to go for our pound of flesh. Let us all give some time to this. Here, as we are talking about Sri Lanka, let's not go for the kill right now. So likewise, in respect of a company, creditors can agree and reach some form of consensus, which might be the best way for a company to resurrect itself from where it is, in order to later ensure that they can repay these creditors in a sufficient manner.
Right. So in these meetings with creditors, does it have to be a unanimous vote, or is there any importance of creditors? How does that work?
Yes, so that's a good question. So there are certain percentages set out in the Companies Act. To my memory, I believe whatever which needs to be approved and ratified requires 2/3, but that's subject to correction. I'm just speaking of memory. So, but there is a minimum threshold.
Okay.
It's not merely a majority. I believe it's a little higher. Most of them will have to agree in respect to this arrangement or repayment plan.
Great. Thank you so much. That was Nishant Sydney Premathi Ratna, attorney at law. Thank you for giving us a lot of information about winding up of a company, and thank you so much for being on this program.
Thank you, Prashant. I'm, as always, privileged, and I'm grateful for the invitation by Law and Order. Thank you very much.
It's a pleasure. And that winds up today's episode of Law and Order. Do join us next time as well. Till then, have a great day.